Welcome back to the Financial Symmetry Show. My name is Cameron Hendricks. I'm one of the advisors here at Financial Symmetry, filling in this week for your usual host, Chad Smith. But we've got a topic today that is a core piece of our wealth management service, and that is estate planning. So one of those topics that doesn't always get the big headlines, when it comes to taxes, the market, et cetera, but one that's important enough that we've brought in an interviewee today. So we've got a professional estate planning attorney here in Raleigh that I'm going to be talking with today during this podcast. So we're going to get some feedback from him, and hopefully it will answer some of the questions that you have and maybe prompt some new ones on your own estate planning. So we've got today Adam Tarsitano. He's an estate planning attorney here in Raleigh, and from our end, it's a piece of the puzzle when it comes to your finances. But I want to throw it over to Adam and kind of get his take on it. So why estate planning? What are we looking to solve for here? So Adam, what are your thoughts there?
Sure. So I think that's almost more of like a logical answer that I'm going to give than a legal one. And that is that people spend a lifetime, literally a lifetime, accumulating wealth, accumulating assets. And to most people, it's extremely important that at the time of their passing, that stuff that they've accumulated over their lifetime gets passed on to their loved ones. It not only gets passed on to their loved ones, but gets passed on to them in the most efficient and orderly manner. Because the thing about estate planning is it's not so much for the folks putting the plan together, it's for the folks who are the beneficiaries, because they're the ones who are going to be dealing with whatever it is that their parent or their sibling or whomever had. And so again, basically for purposes of wills, the goal is to make sure we've got an orderly and efficient transfer of those assets at death. The other part of an estate plan, though, that gets neglected sometimes is power of attorney documents, healthcare power of attorney, financial power of attorney. And the importance of those is to make sure that you have people that you really trust making decisions for you in the event that you can no longer make your own decisions. And the consequences of not having those documents is actually pretty severe because a guardianship might be necessary, and they are miserable proceedings that I recommend that nobody go through. So.
Yeah, it certainly sounds that way, and there's a lot of nuances and complexities when it comes to estate planning. I mean, you just right in there in 30 seconds, you were mentioning different topics and different names of types of estate documents that it's something that we review at least annually for our clients, but it's something that when life happens, when things change, when you want new family members or someone passes away, likely changes your situation quite a bit.
Well, and I think that's a really important point because to me, an estate plan is not just a will. A will is just a will. An estate plan is something more comprehensive than just a document or just two documents. It's making sure that you've got everything in order in the event either that you pass away or that you become incapacitated. And these are real problems. These are real issues. There are simple solutions, but these things do happen. And you've got to be prepared, because if you're not, the consequences for the folks that are either the beneficiaries or the people trying to get this guardianship going, they're the ones that kind of suffer the most.
Right. And that's where, we've brought in expertise via Adam here to help us and our clients spot those areas where things may not be passing efficiently, or there may be some holes in the documents they have or documents they need that, would help their situation so that, things are in place, the next generation, that the beneficiaries don't have to go through such a tough time while they're also grieving the death of a loved one. So we've actually, we collect estate documents from all of our clients, and we've had Adam over the past year or so review hundreds of them. And what we wanted to bring him on the podcast today to kind of give us what were the takeaways? He saw very simple plans, very complex plans, plans for folks in their 20s, plans for folks in their later retired years, and everything in between. And so what we're going to discuss is, okay, so what are the key takeaways? So we'll go through them, and then we'll have some other discussions that may come about regarding estate planning as a whole. But what were your takeaways, Adam? What's one of the first big ones you had?
Sure. So I think the biggest one relates to the documents themselves, but also kind of the bigger picture, and that is how important it is to meet with an estate planning attorney to have these things done. And what I mean by that is, as opposed to meeting with an attorney that specializes in DUIs, for example, just to do your estate plan, or LegalZoom, or potentially a DIY kit that you buy at Staples. Not that those things can't work or that they don't work, but the level of analysis that you'll get from an estate planning attorney is so different from what you get from those other sources, because with those other sources, you're basically providing some information, and then documents are just being kind of created using forms, and then they're shipped to you, or however that might work. But with an estate planning attorney, a good estate planning attorney, they're going to be asking you lots of questions, again, with the goal of trying to figure out the best way to transfer your assets at the time of your passing. It may be a simple will, it might be a revocable trust. For those folks that have accumulated a great deal of wealth where there might be significant estate tax, it might be irrevocable trusts. But again, that's the kind of conversation you need to have with an attorney that practices in that area, that understands the nuances of the laws, understands the nuances of, again, not setting up a will necessarily, but setting up a comprehensive plan. And so one simple way to figure out whether you're dealing with an estate planning attorney or an attorney that practices in 15 different areas, go to the website, check out how many practice areas that firm has. Do they have a team dedicated to estate planning, or are they all kind of handling different things? And again, typically that information can be gathered just from a quick look at the website. But again, my advice would be make sure that the person you are sitting across when you're doing this stuff is an estate planning attorney.
Right. Yeah. And that was something that we see quite often, where we have folks come in with documents that they already have, and in their mind, they're good to go. Things look great. But when we dive down deeper into those documents, sometimes there's a lot of vagueness in the language used. And what you've helped us see is, things may play out the way they were intended, but a lot of times it's better to have that defined specific language in these documents that, professional estate planning attorney as yourself can provide, and versus just kind of a fill in the blank type of online experience that we've had some clients use.
Right. I mean, so, for example, I've seen documents prepared by an attorney, and they are, for example, they use the term personal representative. Now, it is interchangeable with executor to a degree, but you don't use the term personal representative in North Carolina. You simply don't. It's an executor. And so any attorney in North Carolina that's practicing, that's really paying attention, is making sure that their documents say executor, not personal representative. But you do see that, for example, and it doesn't mean that the document's going to fail. It just suggests that it's a little sloppy, and that maybe the attorney didn't have that conversation, that really good conversation with that client, to make sure that the client understood exactly what they were getting, that the client understood all of the options that they had, etc. And so again, it doesn't mean that the documents are bad or that they're not going to work, but it does hint at that these people didn't get the care that maybe they needed.
Right. Absolutely. And it reminds me of, like doing our financial plans. It's just like the estate plan. It's not a one-time document. It's a living document as life happens and things change. Just in the instance you mentioned there was North Carolina specific. Well, in Raleigh, we've got folks moving in from all over the country, and if they've had documents drafted in other states, it may be worth a second look to make sure that things are up to date to what fits their current lifestyle and where they live. So yeah, that's a great takeaway there, Adam. What else? What else were some of the big ones for you as far as takeaways?
Yeah, so like you mentioned, there's all different arrangements in terms of families and all this and all that, but a lot of the documents that I look at involve married couples who do have minor children. And the importance there, the takeaway there at the sort of the macro level is, you have minor children, you absolutely need a trust to catch any share that might fall to them. So typically it's everything to surviving spouse, and then when the second spouse passes away, everything pours into a trust. Now, the thing about the trust, though, is that you need to make sure that what you're getting is called a testamentary trust, not a document that just has a simple holdback trust. I don't want to get too technical here, but a holdback trust is just going to basically catch whatever passes through your will, through your residuary estate. And it's very simple and like very bare bones. Holdback trusts are really designed to catch shares going to folks that really were never intended to inherit. For example, if you have a document that says everything to surviving spouse and everything to my kids, one of the kids predeceases and it ends up going to a grandchild, for example, a holdback trust is there to catch that share. But something that could go directly to a child, a holdback trust doesn't cut it. And the primary problem with the holdback trust is you really can't designate life insurance, retirement accounts. You can't designate that trust as a beneficiary of those. With a testamentary trust, which is still contained in the will and can still be very simple, but it's designed specifically for minor children to be able to catch everything and then distribute it according to the terms of the trust. And so
Right.
that would be probably the biggest thing that I see in documents is that a lot of them rely on these holdback trusts, and it's not only sort of a sloppy way to do things, but it ends up being a problem with beneficiary designations, which are critical, especially when you're dealing with retirement accounts, life insurance, those types of things.
Yeah, which are oftentimes some of the biggest assets that clients will have is their retirement accounts or life insurance policies. So with the testamentary trust that you mentioned, is that something that the individual should put as their beneficiary on these types of accounts? How should they utilize that when it's in the documents? What do they need to do next to make sure it's funded and used?
Sure. So every time I set one up for a client, it's important to discuss with them that, again, typically it's spouse is the primary beneficiary. So spouse would always be the primary beneficiary on retirement accounts, life insurance, but the trust should then be named as the secondary beneficiary. The thing is, testamentary trusts don't exist until both of the spouses are gone. And so basically all you're doing is setting up that designation, providing as much information about it as you can at that time. And then after the second spouse passes away, that's when the trustee is going to really gather up all the specific information they need. They're going to get a tax identification number for the trust and all that. But preliminarily, yes, spouse should be designated as primary, and then the testamentary trust should be designated as the contingent or secondary beneficiary.
Got it. That makes a lot of sense. And you mentioned the trustee there as well, and the terms of these testamentary trusts. Could you give an example of something that someone may put in as the terms? What kind of items are we talking about here?
Sure. So basically, the idea is typically everything's going to pour into this trust. It's going to split into as many equal shares as children you have. So you have 2 kids, it's going to split into 2 equal shares. 3 kids, 3 equal shares. And then you have a trustee who's going to manage those funds on their behalf, making distributions for the things they need for education, transportation, living, until the children reach a certain age. Typically it's 25, but I've put them together at 30, 35, 40, all different ages. And the type of trust that I strongly recommend and that I put together is called a lifetime testamentary trust. And all that means is that when the child reaches that threshold age, the trust doesn't just end, but rather the child has the option to become their own trustee. The reason that I like setting it up that way, and lots of attorneys like to set it up that way, is because as long as the assets are in trust, they're protected from the children's creditors. So by giving them the ability to become their own trustees, you're also giving them the ability to continue to protect that money from their creditors. Say at 30, one of your children is going through a divorce. All of a sudden, they become their own trustees. They can say, you know what? Now is not the time to take this money out of the trust. I'm going to leave it in the trust. I'm going to keep it protected from divorce, from a judgment creditor, from even bankruptcy. And so those are kind of the standard terms that I like to use. And they are what we call discretionary trusts, meaning that you are really relying on your trustee to use their discretion as to what to use those monies for the benefit of the kids.
Right. Makes sense. Okay, so that's going to be primarily for those individuals that have minor children at home. They're going to want to have these testamentary trusts set up with their will, and think about some of those nuanced terms that they want to put in that trust when it's drafted. Okay, so we've got the trust for the minors. We've got having a qualified professional to look over documents with you. What was another big item that stood out to you? Did you have anything else?
Well, I think there are little sort of things that pop up here and there. Each will is different. But I think another one is, and it might seem very simplistic, but I do see it a lot, and that is just making sure that your documents use full names of the beneficiaries, for example, full names of the trustees, full names of the executor. It might seem like a minor point, but it really is important, especially in North Carolina. Also having the folks, the testator and the testatrix, make sure that their full names appear on the documents, and that when they're signing the documents, they're signing just as their name appears. Again, it might seem like a minor thing, but down the road, it can lead to issues. Also, identifying who folks are. My son John, my daughter so and so, my brother full name, my sister full name. I come across documents all the time where it just says, John Smith. Well, how many John Smiths exist? So many. John Quincy Smith, well, maybe not as many, right? My brother, John Quincy Smith, well, guess what? There's only one person that fits that bill.
Right.
And so, again, contextually, you can usually figure out who they're talking about, but why even have to go through that exercise when it's just as simple as saying my brother, John Quincy Smith in the document.
Right.
And so lots of little things like that. And so my advice to folks is make sure that A, your attorney is asking for those full names. And B, when you're looking over the document with the attorney, just make sure that all those names are correct. Make sure that the identifiers are correct. And again, it'll save a headache down the road. And also it'll prevent you from having to go back to that attorney, 2 weeks later saying, I found an error in the document, and how do I have to come to your office to get this fixed? Do they need to be re-witnessed and re-executed? Yes, the answer is yes. And so it's just a giant inconvenience too.
Right. It sounds like it. And that's, and it would be an even bigger inconvenience potentially if it were to stay that way. And upon death, this was having to be dealt with and combed through to make sure the money was going to who you intended it for. So it's just much easier to get it right the first time and go ahead and have it set up correctly from the beginning.
Exactly.
Great. So, these are some big takeaways, and these are certainly things that are going to help our clients that we've had to go back and make some adjustments to. For those at home that may, have estate documents in place, what are some things, say they got them done 10 years ago? What are some things that, if occurred in the last 10 years, would require them to probably take a second look at them? And what are some of those big trigger points that could come up?
Sure. I think the biggest is definitely if they had a will prepared at a time where they had minor children, and so they couldn't name their minor children as agents on healthcare power of attorneys, for example, or agents on financial power of attorneys. But those documents were done 12, 13 years ago. Well, now their kids are 25 and 28. They're not minors anymore. And maybe it's time for them to become the folks that are the backups behind spouse on healthcare power of attorneys, financial power of attorneys. Maybe they don't really need a trust in their will anymore. They don't need those testamentary trusts. They can simply say, hey, everything goes to my spouse and then everything goes to my two children in equal share. So definitely sort of the natural progression of time and what that means for families. My advice is every 2 to 3 years, pull out the documents, look them over, make sure the goals are still the same, make sure the people you've named are still capable of acting. And if that's the case, you put them back away. But definitely a main one is children growing up, yet they still have, their uncle designated as their backup. And if they had just looked at the document, they'd realize, well, that doesn't make sense anymore. I don't need my uncle or my brother to be my backup because my son or my daughter is now fully capable of doing that. So that's one. Another would be potentially just changing goals. So you had a plan that originally sent things to your siblings, and you've decided that maybe I'd rather give it to a charity, for example, or I would rather make sure that it goes to whomever. Point being that if your goals change, you need to remember, I need to change my documents to match those goals. On a bigger picture, for example, if it looks like your wealth has grown, you've accumulated assets that puts you at risk of having to pay estate tax. Well, that's certainly something that you would want to go and talk to an estate planning attorney about because the consequences of not dealing with that are pretty significant. And so, a change in circumstance with wealth would be another reason why you might want to look into it.
Right. Which is also, kind of a lot of those are items that, it often helps to have a team that is looking out for you, where your financial advisor may be aware of new, financial assets coming into play. And so coordinating with the estate attorney to make sure that the documents you have don't need to be updated, or if they do, how do we go about doing so?
Sure. And I've had the pleasure of coming to your office and sitting down with clients that, that are close to that threshold or even above that threshold. And, like you said, giving them that comprehensive assessment, that comprehensive analysis, it's extremely helpful.
Right. Absolutely. And which is why we, put some emphasis on it, on the estate planning. So, and one thing that comes to mind though is, what about those individuals that have not put an emphasis on their estate planning? What about those individuals that are dragging their feet, or just don't think they need a plan? What happens if they were to pass and don't have estate documents? What is there a default? Is there a what's the order of operations if that happens?
Sure. And the thing about, so they're called the laws of intestacy. And basically what it means is if you don't have a plan in place, the laws of North Carolina are going to step in and tell you what's going to happen to your assets. So where you had this opportunity to decide for yourself what you want to happen, that opportunity is missed. And now North Carolina steps in and says, well, this is where they're going to go. Now, there's lots of different scenarios, so it's hard to get into the details of the laws of intestacy, but I guarantee you most people would be very surprised by what's going to happen under a lot of those circumstances. It's not what you would have wanted. And they're also sort of complex. So just for example, if you pass away with a spouse and parents, no child or no children, you'd kind of expect that everything would go to your spouse. That's not the case. It actually, at some level, would be divided between spouse and parent. And so, again, that's just not something that you would anticipate or expect, but it would happen. And like I mentioned earlier, it's not just the will, but it's also those power of attorney documents, because at death, of course, we're talking about the will, but while you're living, you're in a car accident, you bump your head, you can't make financial decisions, you can't make healthcare decisions. If you have those documents in place, you can rest assured that your spouse or your brother or your child is going to be able to step in and handle those things. But without those documents, you got to go to court. You have to have the person declared incapacitated. And once they've been declared incapacitated, then the court picks, who is going to be making those decisions. And not only is it a hassle, but it's costly, because you need to hire an attorney to go and handle these guardianship proceedings. And it's so much cheaper just to have power of attorney documents in place.
Right. Yeah, absolutely. You got to have these things in place before the event occurs. And that's what, a lot of times when we're talking to prospects or folks out in the community that haven't worked with a planner before, they're like, oh, well, a will is something that I need upon my death. And, I worry about that, maybe when I get to retirement age or something like that. But really, it's sounding like, those that are in their 20s and married without kids, they need something in place. At any age range, some of these non-will items come into play, such as the power of attorney and something to help make decisions for you if you're unable to.
Well,
so it really spans all age groups.
Well, you're right. And in case in point, it's become sort of more common knowledge now, but only sort of more recently. And that is that even an 18-year-old child, well, they're not children anymore under the law, that they are adults. And so parents kind of expect, well, if my 18-year-old is in the hospital, of course I get to make the decisions. They're my child and they're my kid. The reality is at 18, they're adults. And so do I think an 18-year-old needs a will? Not really, but should they maybe, especially if they're going away to college, have a healthcare power of attorney in place? I think that it's not a bad idea.
Right.
And parents run into the issue all the time where, again, they just think, well, of course, I'm the person that gets to do this. But once they're 18, that's not always the case.
Yeah, no, absolutely. As somebody with young kids, right now we're thinking and making the decisions for them. And when they're 18, that changes. And that's I imagine that a lot of folks that, don't think about that, as one of those, hey, they're going off to college, we need to buy them textbooks and a laptop. We'll also look at getting a healthcare power of attorney as well.
Sure.
So, well, great. Thanks, Adam. And, I think those were some great takeaways, upon reviewing so many estate documents for us. And then even, here at the end, discussing a few other just things to look out for when you're an individual and thinking about your future and your estate plan and the next generation. As we wrap up here, what can you give the listener as a takeaway? Chad likes to call them progress principles. What's kind of that? Is there one thing that someone should think about and do? Where can they start? What with estate planning? Do you have a key, something to send off the listener with?
Yeah, so I think that there was a time where perhaps everyone didn't need an estate plan. But at this point in time, everyone really does need an estate plan. It doesn't matter whether you just have a few $1,000s or you have $25 million or whatever you have. You really need a plan. And again, it's not so much for the people that are doing the planning, it's for the people that are left behind. But as far as a starting point, I think it comes down to being responsible. And that's what I was saying with the fact that it's not really for the people planning, it's for the people that are going to benefit from having a good plan, the beneficiaries. And so I think at some point, it's just important, especially, the idea of having the laws of intestacy control where these assets go, these assets that you worked your whole life for. To me, that's terrifying, that thought. And I think it's probably terrifying to a lot of people, but not everybody's aware of it. But I think it's just educating yourself about estate planning generally, and then certainly meeting with an attorney who can get into the specifics of what you need. Can you get away with a simple will? Do you need a revocable trust? Do you need an irrevocable trust because you're facing certain specific circumstances? And so I think it's just about sort of educating yourself about the general ideas, and then meeting with an attorney to kind of flesh out the specifics.
Absolutely. And thanks, Adam. That's perfect. And, I think speaking of educating yourself, talk with your professionals in your life that you're already working with, and so that you can educate yourself, or, even check out, our website, Financial Symmetry. We'll have this podcast episode up with contact info for Adam, and as well as some links that we have on educating yourself when it comes to estate planning. So when you're thinking about your whole comprehensive financial picture, taxes, insurance, investments, etc., also think about this estate planning piece. And I think that key step of educating yourself is great. So thanks, Adam. Thanks everybody for listening. We'll catch y'all next time.
Thank you all very much.